Good evening and welcome to this presentation on parenting coordination, rules and ethics. I am Amanda Wall and thank you for being here with me. This is my contact information. I am an attorney practicing family law. I'm of counsel to the law firm of Fournier Law in Tallahassee, Florida. I'm also a parenting coordinator and a guardian ad litem. And prior to practice and working in the Second Circuit as a family law attorney, I was also a family law magistrate in the Second Circuit for 6 counties that make up the Second Circuit, and I did that for 6 years. My contact information includes my email and my phone number. So if you want to take a moment to write that down or to make note of it, I am always available to discuss anything to do with parenting coordination issues, with the rules, or with other topics in regard to parenting coordination. And I enjoy doing that. So, alrighty. So our agenda for today is what we'll go over next. And what I'd like to address with you all is first the qualification and circuit disqualification and renewal that is found in the rules 15.000 to 15.020. The second section that we're going to be in the largest, really, that we're going to be going over is the standards of professional conduct. And that is from rule 15.200 through 15.298. And then lastly, discipline, which we will briefly go over as well. And that is rule 15.300 through 15.385. So the authority for the rules come from really the Supreme Court of Florida. Office of State Court Administrator is part of the Supreme Court of Florida. And within that Office of State Court Administrator is the Florida Dispute Resolution Center. The other form of authority is from the Florida statute, and that is Florida Statute 61.125 that we are going to go over today. Just wanted to talk a little bit about the other area of authority, which is through the rules that were promulgated by the Supreme Court and the Dispute Resolution Center, which handles cases for and regulation for mediators and for parenting coordinators. They are the body that handles complaints and investigations as well. The DRC is a great resource for you for free continuing education hours for mediators and for parenting coordinators. There is a list available. There are tons of free courses listed by the center that you can easily access just by the click of a mouse. And you can obtain all of our needed as parenting coordinators, our needed hours for the next reporting period without having to spend $400 on a 2-day course. The DRC has that available, and they are just super helpful in answering questions for you. And it's just a terrific resource. So with this second authority that we're talking about here on this slide, the Florida Statute 61.125. I've kind of skipped the first section. You'll see here I went right to 2 because the first is just really definitions. So the second is giving the purpose of parenting coordination, which is really a child-focused, non-adversarial dispute resolution process that is court-ordered or agreed upon by the parties. And the parenting coordinator should help to create and implement a parenting plan and help resolve disputes that occur between the parents. Providing education to the parties and family members teachers to every person involved, really, with the children or child. It can be grandparents and siblings, aunts and uncles, whomever. Providing education is a big part of our job as parenting coordinators, and making recommendations on what should occur with a child, on what decisions should be made, on what resources that are available that should be applied to the case. It's really, really in our best interest to know what is out there education-wise to give to families, to children, and what is out there as far as recommendations to help solve those problems. So we are a great resource, sort of a housing place for resources for the families that we serve. A great teaching point in this regard is childhood trauma, and having the education materials available in your office for the parents and family members to really deep dive into the importance of them understanding childhood trauma, and how childhood trauma and adversity, how toxic stress and high conflict are affecting their children. I have another talk on that topic, which is childhood trauma, being aware and responsive, that I've prepared for the DRC. And I will briefly go over that, just very briefly a little bit later. But basically, it is important to have that, as I said, clearinghouse of information, educational information that you can give to everyone you're serving in the case. And that's really what is statutorily mandated. So 3 is referral. That's part of the statute. And so it's really just saying that you can be referred to a parenting coordinator by the court's own motion or the motion of a party. And the court can appoint a parenting coordinator and refer the parties to the parenting coordination to assist in resolution of disputes in regard to their parenting plan. So it's giving that authority for the court to do so. Domestic violence issues in number 4 is something that is also important statutorily to understand. The court may not refer parties to parenting coordination unless both parents consent, if there has been a history of domestic violence. And really, there are many cases where parenting coordinators are involved. The court has to determine that, and it should be the parenting coordinator that is constantly checking in and ensuring that there isn't any concerns in regard to domestic violence if you're taking a case that has a history of that. And what do I mean by that? So how you treat that case is different than you may treat your other cases. So you may only have Zoom conferences with those parties. You may not want to have Zoom conferences where you have obviously the parties in the same Zoom room. It's a difficult sort of very fine line that we walk when we are trying to deal with these cases as parenting coordinators, because of course we're trying to facilitate and initiate and support communication between the parents, which is the best way for them to be able to deal with issues of their children. But when you have domestic violence issues where a person is truly in fear of the other person, you can't, it's hard to do that. And so it really is by the appointment of the court where the court has made that determination that you can even be in that situation. And then you need to have practices that you investigate, research, find the best practices when you deal with these situations, and be very mindful and constantly checking in regard to those. Okay. So qualifications is, a big part of obviously the statute. And so qualifications are In the green that I've highlighted is unless there is a written agreement between the parties, the court may appoint only a qualified parenting coordinator. So that means parenting coordinators that are part of the circuit list and have gone through the approval and through the training. And so to be qualified, you have to meet one per statute of the professional requirements, either a mental health professional, physician that has certification by the American Board of Psychiatry and Neurology, or Florida Supreme Court family law mediator, or a member of the Florida Bar in good standing. And then you have to complete all to be qualified of the following in the blue: 3 years of practice, 3 years of post-licensure or post-certification, whatever your expertise area is in, but you have to have 3 years of practice. A family mediation training program that was certified by the Supreme Court of Florida, and a minimum of 24 hours of parenting coordination training that includes ethics, family systems theories and application, and such, and 4 hours of training in domestic violence and child abuse. So there's a lot of, parts to Section 5 for qualifications. And so I've kind of boiled it down for you to meeting one of the following on the left, meeting whether you've been a healthcare professional, physician in psychiatry, neurology, certified family law mediator, or a member of the Florida Bar, and completing all of the following, which is 3 years in practice, certified family mediation training program that you've completed, and a 24-hour parenting coordination training with a minimum of 4 hours of the domestic violence or child abuse. Okay. The next section of the statute talks about disqualification of parenting coordinators. And so that's really that there has been something that has occurred that disqualifies you pursuant to what the statute is saying here, which is a conviction or an adjudication withheld in the area of child abuse, child neglect, domestic violence, parental kidnapping, or interference with custody, because of course, it would be a concern. Or if you were found by a court to have abused, neglected, or abandoned a child, or consented to a petition for dependency in your own case, or a respondent in a final order or injunction of protection against domestic violence. So any of these things would make you disqualified, even though you have the qualifications and you've met the 3 that were mandatory for you to do. With the training, you would still be disqualified. And this is all within the purview of the chief judge of your circuit. Okay. The statute talks about fees for parenting coordination. And so the court shall determine the allocation of the fees. That is nice if it's in your order specifically as to what your retainer is and what your hourly is and how the parties are going to be paying for it. The court may not order the parties to parenting coordination without their consent unless the court determines that the parties have the financial ability to pay. Ability to pay is important. If the court's ordering it on its own order. And so sometimes, what the court may do, if a party is found to be indigent based upon the factors that the court looks at, the court may not order the party to parenting coordination unless there's public funds available. And at least in our circuit, there isn't such a thing. Or the other party is paying for it. So statute also talks about confidentiality. Very important. It is, there are some exceptions, so we can go over that in the yellow portion. The confidentiality is that the parenting coordinator may not testify or offer evidence about communications made by, between, or among the parties. and the parenting coordinator during parenting coordination sessions. Sessions are confidential. This is to make it so that people will feel comfortable and they will feel confident that being in these sessions is something where they can disclose information, and that it's not going to just be that you are becoming a paid witness in the case, but that it is truly for the purpose of, helping them to become aware of issues and how to solve those issues. So very important in the statute, very important concept. There are exceptions in blue. Necessary, if it's necessary that a parenting coordinator testify or communicate information, if it's necessary to identify a written agreement during a parenting coordination, if it's necessary to identify an issue for resolution by the court without otherwise disclosing communications made by the parties. So if there's an important issue that's being brought up in a motion or in something before the court that is really, for instance, pertaining to the child or children, that is an immediate, that has to be addressed without disclosing the actual communications, just to identify an issue. An exception is if the testimony or evidence is limited to the subject of a party's compliance with the order of referral. So if one party is just not complying and you need to go up before the court to talk about that, that's okay. Again, it is important for the compliance with the actual order that has been entered. And then the parenting coordinator can report, of course, that the case is no longer appropriate for parenting coordination. And you're allowed to do that as well. And I've actually had to do that in a few cases. The parenting coordinator is reporting that he or she is unable or unwilling to continue to serve. You can testify to that. The testimony or evidence that the parenting coordinator has is necessary for paragraph 5B or subsection 8, and which we'll get to, and the parenting coordinator is not qualified to address or resolve certain issues in the case. And so they're saying basically, I can't serve because I'm not qualified on these particular topics. The parties can agree to say, you know what, we agree that the parenting coordinator can testify in the case. And so that is an exception. The parties agreeing can be part of something that occurs at the very beginning of the case when they enter into the parenting coordination process. Or it can be that for a particular topic, just for that particular topic, the parties say, hey, we do want you to testify about what happened about the school issue. And if they do so, then you're able to testify and to not be considered a breach of confidentiality. Of course, if testimony is necessary to protect persons from domestic violence, from future domestic violence, from child abuse, neglect, or abandonment, exploitation of elderly or disabled persons, or abuse or neglect, that type of testimony is also you are allowed to talk about, and to not be considered that it is confidential. It's an exception to it. Parenting coordinators are to report, an emergency to the court, meaning that they are mandatory reporters, like many of us in the court system are. So if a parenting coordinator must immediately inform the court by affidavit or verified report of an emergency situation if it's suspect that a child's going to suffer abuse, neglect, or abandonment, suspect that a vulnerable adult has been or is being abused, neglected, or exploited, expected to wrongfully remove, that a party in this case might wrongfully remove or is wrongfully removing a child from the jurisdiction, or to avoid domestic violence. So a coordinator, for instance, should not be disclosing locations of a parent and a child unless required by the court. if a parenting coordinator suspects that there is, you know, a relocation of a parent in order to avoid domestic violence. And then to inform the court by affidavit or a verified report that a party obtains a final order or an injunction of protection against domestic violence or is arrested for an act of domestic violence. So informing the court of those types of emergencies is also something that is allowed by statute. The statute also talks about the limitation of liability for you, so that you are protected. Section 10 protects you from civil liability. Parenting coordination clients are some of the most difficult people in the court system, as we all know. So having a protection against one of them suing you for damages is essential, or you really couldn't do your work because of the exposure. So Section 11 is basically statutorily mandating that the Supreme Court is going to establish ethical standards, conduct, discipline for parenting coordinators who serve under that section. So that is kind of giving statutory, obviously, authority to what has been created through the Supreme Court, through the Office of State Court Administration and the DRC that we talked about a little bit earlier. That's giving the authority, Section 11 is giving them the authority to be doing that type of thing. Okay. So to qualify and start your practice, you meet the requirements of the statute and you fill out the circuit application form for one or more of the 20 judicial circuits in Florida. I am only a parenting coordinator in the 2nd Judicial Circuit, but there are many people who are parenting coordinators in multiple circuits. You just need to fill out the circuit application. You can apply to more than one, as I've just said, and the chief judge of each of those circuits reviews if you meet the requirements in the statute and then approves you to be included on the roster for that circuit. And then basically you're listed on the roster, which is on the circuit website usually, with your name as a parenting coordinator, and it kind of gives a little bit of information about your fees and you know, a little bit about the type of cases that you take. Okay, disqualification. Reasons for disqualification is found in the statute, as we've just gone over. And so child related and domestic violence statutes, Section 7 is something to just, as we've gone over, look at. The chief judge of each circuit reviews their roster of qualified parenting coordinators, making sure that they're still qualified. They're supposed to do that to ensure that someone is no longer on the roster for the circuit if they've actually been disqualified at some point. And if you appeal the disqualification, then the chief judge of each circuit makes the decision as to whether or not you should be disqualified. But those disqualifications, as we've just gone through, are pretty clear and pretty straightforward. Okay, so renewal. Every odd year before December 31st, submitting your 16 hours. You submit your renewal application form to your circuit chief judge, and that circuit chief judge usually has a designee who's going to be taking that information, checking you off the list that you are still properly qualified and that you are renewed. If you don't have enough continuing education hours, but all other qualifications are still satisfied for renewal, you'll be notified in writing and you'll have 90 days to complete your hours. And again, lots of resources for that. There's programs, of course, out there that you can go to and pay for. But there are, as I said, a lot of resources that are free on the DRC's site for parenting coordination. And it's a great resource to take advantage of. Okay, so now we're moving on to our next section, which is the meat of everything. It's kind of the standards of professional conduct. And again, I won't have time, I am sure, to go over every one of the rules that are in the standards of professional conduct, but we're going to hit the big ones and talk about those. The purpose, let's see here, we'll move on to the purpose of parenting coordination, as we discussed just briefly from the statute, is child-focused alternative to dispute resolution that focuses on the needs of children, the needs of the parents and the family. Parenting coordination is problem solving. That's what it's supposed to be, through communication, through education, and facilitation of parenting time. Parenting coordinators are drawing from skills and knowledge of law, conflict resolution, and mental health. So Rule 15.215 talks about competence. And competence means that you are regularly participating in educational activities, promoting your professional growth as a parenting coordinator. You have a duty to withdraw if your competency is somehow impaired for some reason. A duty to decline or withdraw if a case is beyond your skills. We talked about that a little bit earlier in the other slide. If you know that you are handling a case that has some issues that are just beyond your skill set. For me, for instance, I'm an attorney and a mediator and a parenting coordinator. And so when it comes to a lot of mental health diagnosis issues, if there was something very serious that would be beyond my expertise area, and if I didn't feel that I could have other professionals on the case to deal with it, that would be something that would be an issue to bring up for myself, to say perhaps a parenting coordinator that had that type of expertise would be better. You have a duty to have current knowledge of all statutes, which is why I just went through the statute of 61125, the rules, which we're currently going through, and administrative orders in your circuit. Rule 15.220A, it's the entirety of Rule 15.220 is integrity. That's what it's about. So there's other parts to it, but we're going to start with A as our first topic, but also as a very interesting topic. So avoiding dual relationships. What the rule says is that you shall not accept the role as parenting coordinator if there has been a prior personal, professional, or business relationship with the parties or their family members. A parenting coordinator shall not enter into a personal, professional, or business relationship with the parties or their family members during the process, or even for a reasonable time after. Okay, what is the definition of a reasonable time? I can't tell you what that is yet. So, so we will see what is a reasonable time after. I suppose by cases coming before the panels. However, it's an interesting topic, dual roles. And the reason it's an interesting topic is because there are differing rules for differing disciplines. So let's get into that. I'm going to give you a hypothetical. For lawyers who are parenting coordinators in particular, a hypothetical is you are a lawyer, a family law mediator, and a parenting coordinator. You are conducting a mediation between two parties who are both represented by attorneys. During the mediation, both attorneys and both parties ask you if you can be the parenting coordinator after the mediation is concluded. You have no reason to believe that you are in any way prejudiced or have any conflict between or conflict being the parenting coordinator after mediating for these two parties. And you explain to them that you would need both parties to provide a waiver and informed consent. And they do, along with both of their attorneys. And so you're off to, you finished the mediation and you are now meeting with them as a parenting coordinator. You're their parenting coordinator for several months, and through the process, it is clear that the father in the case is a very difficult client. He is bullying to the mother and to you. manipulative, uncooperative, and extremely high conflict and aggressive. And that person becomes increasingly unhappy with your services as their parenting coordinator because you do not allow him to bully the mother or manipulate the process. And he becomes angry, aggressive, and very high conflict as a result of that. This client tries to orchestrate having you removed from the case because he doesn't like the results that he is receiving as far as recommendations and feedback. And so he makes a complaint against you saying that it was inappropriate for you to be his mediator and then become his parenting coordinator. Is his complaint valid? So, well, you based your initial acceptance in this case of this client and his attorney asking you to be the parenting coordinator on what you know as an attorney and a mediator. So let's look at that. Florida Bar Rules of Professional Conduct. The Florida Bar Rules of Professional Conduct, Rule 4-1.12. So it's 4-1.12. Is a rule providing for former judge or arbitrator, mediator, or other third-party neutral. And representation is what the Florida Bar Rule says. Representation of private clients by a third-party neutral. Except as stated in the subdivision, a lawyer shall not represent anyone in connection with a matter in which the lawyer participated personally and substantially as a judge or adjudicative officer or a mediator or third-party neutral, unless all parties to the proceeding give informed consent confirmed in writing. So in our hypothetical, as a lawyer, it would appear that you would not have, as the lawyer mediator, any type of conflict if you were trying to have those types of dual roles, or not dual roles at the same time, of course, but just that you had that type of experience in both of those roles with the client. It's generally thought to be something that you should not do, obviously, by the way it's written, but there is the ability for the client to have informed consent. So like in this situation, to have his or her attorney talking to them about it, for them to understand, for the disclosure to be made, and for that person to in writing say, yes, I understand all these things, but I still do want this person, right? So that rule, when we look at it as compared, to the parenting coordination rule. In our hypothetical, we're saying this is why, in the hypothetical, you asked for the informed consent and waiver before you began as the parenting coordinator for those parties, right? However, it's not right. You're wrong. Because Rule 15.220, avoiding dual relationships, says, shall not accept the role. And there is no exception at the end. So the difference is that in the Florida Bar Rules, of course, it is also a rule to say we don't want you to do that. However, if you obtain that consent, it's an exception. Here in the parenting coordination rules, it is not. There is no exception. So it's a very interesting point. Very different. Both rules say shall not, but there is an unless clause. In the parenting coordination, it's shall not, and there is no exception. So in this situation, in our hypothetical, you would be in violation of the parenting coordination rule, even though you are not in violation of the Florida Bar Rule. So it's a little bit more restrictive on that particular rule than the Florida Bar Rules regarding dual roles. Okay, so let's move on. The rest of 15.220 and the rule and integrity is the section, talks about many other things, such as Respect for diversity. You can't allow your own personal values, morals, or religious beliefs to undermine or influence your role as the parenting coordinator. It's a really important point because we all do have our own personal values and religious beliefs and morals. And those things are things you have to leave behind in your role as parenting coordinator. There is no inappropriate activity, of course. You cannot harass or exploit clients or their children or employees or your colleagues generally. No misrepresentation of facts or circumstances because we want to keep the integrity of the process. Demeanor in E, a big part, big important thing. To be patient, dignified, and courteous as part of the integrity of the process and of being a parenting coordinator. Maintaining integrity as a parenting coordinator and avoid coercing or unfairly influencing the parties in any way. Okay, so let's talk a little bit more about 15220E when we were talking about demeanor and being patient and dignified and courteous. So how do you do that effectively? How do you do it consistently when you have high conflict people? So how do you manage those high conflict people? High conflict personalities, HCPs, high conflict personalities. High conflict personality is often associated with a cluster of symptoms such as grandiosity, impulsivity, rage, paranoia, fear of abandonment. People with HCP may be unable to accept responsibility for their actions and may be easily triggered into high levels of anger in situations where they feel slighted or misunderstood. They are the high conflict people of our court system, and that's why they are with you. Not as a last resort, but you know, the reason parenting coordinators are there is because people are so high conflict. So you have to, understand that it's not easy. Obviously, those of you who have been practicing for a while know that and how difficult it can be to stay patient and to stay courteous and to stay professional. People with HCP usually have an underlying personality disorder, such as borderline personality, narcissistic, antisocial, histrionic, paranoid. Estimated that 9% of the US adult population have at least one personality disorder. And so it's not a huge percentage of the population that we are dealing with. But you can, I'm sure, in some of your cases, recognize, for instance, the histrionic personality disorder or the paranoid personality disorder. HCPs often, in their own mind, believe they have a bond with the person of authority, believe they have a close, strong relationship with you if they see you as, court appointed as a person of authority. With you as the parenting coordinator, the HCP may believe he has a special relationship with you, and they behave differently. HCPs behave differently depending on their perceived bond with you. They're always discerning nonverbal messages, and they escalate their behavioral disorder in your sessions because of any criticisms that you might have. When dealing with a high conflict personality, you do have to have empathy and show that you have attention and that you have respect. It is difficult, again, at times to continue in that demeanor when someone is being especially difficult or bullying or abusive in some way. But it is the antidote, in a sense, obviously, to the HCP, to the high conflict personality, is to have empathy and the attention and the respect being shown. And you need to use management techniques, obviously. And that will help you so that you can stay patient, so that you can stay courteous, so that you can stay professional and you can stay within the rules. Having structure is a really important part, and consistent structure that the parties understand and know is going to happen with you. Having consistent policies, taking small steps at a time in whatever you're doing. When someone is very high conflict, moving them along very slowly towards a concept or a point or a realization, or a solution is important. Informing the person, the high conflict personality, clearly of your expectations and recommendations, and have consequences. If someone is bullying, if somebody is out of order and is hijacking the process in a way that is very unhealthy and that is harming the other party, then you need to have consequences. The consequences can be just immediate stopping of a session, or allocating fees differently based upon their continued bad or negative behaviors after you have recognized them and you have tried to address them with the person. Think of ways that you can be innovative in order to do that. But having those consequences is important. And of course, the consequence can always be going to court and, asking the court for assistance. High conflict personalities. High conflict is toxic stress to children. High conflict is an adverse childhood experience for children. And without intervention, without stopping it, without changing that trajectory, it can mean negative mental, physical outcomes for the children in their future. Of course, we all know that. But actually having clients accept and understand that is a game-changing event if you can do it. HCPs can cause toxic stress and trauma to their family members. So follow Rule 15.220E, which is your demeanor, but you must also protect the children in the case from toxic stress and further trauma. Educate the parents on what behaviors, language, how high conflict affects the child or children. You must be patient and courteous, but you should also be firm that you will not tolerate certain behaviors and that each party will be respectful to the other party and there's going to be a consequence. Following the rule doesn't mean that you, as a parenting coordinator, don't set expectations for behavior and set consequences for behavior. In fact, I would argue that is being and following what the rule mandates, which is being professional and courteous, because you're also being courteous to the other side of that equation, who's experiencing that negative behavior from the person, the high conflict personality who is exhibiting it. So just very briefly, because that's not what this whole talk is about. We're here on ethics and on rules. But as far as children are concerned and these high conflict personalities that we deal with, learn about, know about, if you don't already, many of you probably do know about this, but the ACE test, which is the Adverse Childhood Experiences test, and concept for the court system and for us as court-appointed parenting coordinators. It is something that there's a lot of information on. It has been in child science and development education for the past several years. Read about it, learn about it. Basically, there is a test that you can find online by putting in, childhood, adverse childhood experiences tests. And when you find it, it is a 10-question test that deals with what I've listed here, that the physical, if a child has before their 18th birthday experienced physical abuse, emotional abuse, sexual abuse, domestic violence, mental illness or mental health disorders, of people around them, the adults around them, or other people around them, younger people, substance use disorder, incarceration of a family member, parental separation or divorce, which is why you're probably in the case, emotional neglect or physical neglect. If a child has an ACE score, it affects them and it affects their behavior and the trajectory of their life. And so become informed on these topics. I can't urge that enough. It is also a great way of how you can have strategies to deal with these high conflict personalities that cause you to have conflict with your own rules as a parenting coordinator. And again, those rules to be patient and courteous and professional at all times. Okay. So become trauma aware and informed. Make your practice responsive to trauma. Be a resource for information for your clients. Have each parent take the ACE test. They don't have to share it with you, but have them take it and talk about what it means, what the test means, and what it means for children, and what it does to children in their future. Have the parent discuss with you and fill out the test, but you don't have to, as I said, intrude upon their privacy necessarily. They may want to share it with you, but you can do things to have this awareness level so that you can begin the discussion of how to deal with the toxic stress and the high conflict that the children in this case may be experiencing. Let's move on to another rule, Rule 15230, which is impartiality. Your parenting coordinator needs to have freedom from favoritism or bias. Advise the parties of any personal bias, prejudice, or impartiality. Don't be influenced by outside pressure, fear of criticism, or self-interest. Don't accept gifts or favors from the parties or from anyone in the case. Avoid, or that could be in any way surrounding the case. Avoid family, business, or personal relationships so you do not affect your impartiality, and withdraw if you are no longer impartial. Okay. Conflicts of interest are prohibited. So Rule 15.235, a matter that presents a clear or undisclosed conflict of interest. You have to disclose any conflict, and you cannot solicit, encourage, or otherwise incur future professional services with any party. These things all seem fairly obvious. However, again, a matter that presents a clear or undisclosed conflict of interest, you may find something that occurs later that is somehow a conflict of interest. That's okay. You just must disclose any conflict of interest. Okay. Then Rule 15.240 deals with sort of a mandate to be conscientious on your case, do your scheduling, avoid delays whenever possible, and perform services timely. Don't let time go by too long. Don't let there be gaps in your communication or in your attempts to schedule with parenting coordination clients. Stay involved. And of course, you weigh that with times where there's less going on in the case, right? As a parenting coordinator, it's sort of in waves in a sense. There's times where it's extremely high alert and high conflict, and there's a lot of issues going on. And so you're regularly involved and engaging. And then there are times where they're just sort of communicating back and forth. So just keeping in mind, obviously, that you are trying to move the process along. Okay. Rule 15.255 is to deal with advertising and marketing, basically. You're prohibited, of course, from having false or misleading advertisements or marketing. You have to be accurate and honest in what you're putting in your advertising. Don't make claims of achieving specific outcomes. So you're not going to say, parenting coordination services, that you're guaranteed, a whatever type of outcome about education, maybe, or for the children, or you're guaranteed an outcome of a, peaceful coexistence in making decisions for your children's medical needs, or something very specific of achieving that outcome. Just not making those types of outward claims, because we're trying to obviously maintain professionalism. It's not, you're not like, I use the example of selling cars, this is not that type of thing. It is a professional, serious, and very important service that is provided by parenting coordinators, and it should raise to that, level of respect when it is being advertised or marketed. Don't use the term qualified parenting coordinator unless you indicate the circuit you're qualified in. So for instance, if I have, that I, at the beginning, said I was a parenting coordinator, had I said I was a qualified parenting coordinator, I would want to have said, I am a qualified parenting coordinator in the Second Judicial Circuit. So that's, it's a fine point, but just so that it's not, again, having any type of misleading higher sort of status in some way that the client wouldn't understand. If you were a prior magistrate or judge, prior magistrate for me, if you were a prior magistrate or judge or administrative hearing officer, do not imply that your prior adjudicative experience makes you a more qualified or better parenting coordinator. So in your advertisement and in your marketing, not to say, if I said I was a, magistrate for 6 years and that makes me better than the other parenting coordinators in my circuit for some reason, that is inappropriate and it's not professional. No marketing that demeans the dignity, obviously, of the parenting coordination process, which is what we basically have said. Okay. And then Rule 15.260 from our hypothetical earlier that we had in Rule 15.220A about dual roles, where the Florida bar rules have an exception to dual roles, but the parenting coordination rules do not have any exception. This rule 15.260 is talking about concurrent standards. That's the rule. So specifically, it says that these rules prevail. These parenting coordination rules prevail over any conflicting ethical standards to which a parenting coordinator may otherwise be bound. So again, this rule would also reinforce that under that hypothetical, the dual role is, of course, not allowed. Okay. Rule 15.270, confidentiality. Again, in the statute, we read about that, right? And we talked about it. And so here it is in the rule as well. And confidentiality shall maintain all communications as confidential, except when required by law or permitted by law or court order. And those we went over specifically in the statute, but if a court orders you as well, if you go into, a courtroom and they order you to testify about a particular topic, it is allowed. It's an exception. A court's order telling you that the court is telling you it is important and essential for the court to know this information, you can follow the court order. Shall maintain confidential off records developed or obtained. So maintaining all of your records that you have either made, so your documents that you have in your file that you've made in your electronic file, or that you've obtained from other sources, you need to maintain as confidential. That you shall not disclose the identity of parenting coordination clients when you are teaching, like in this instance, like hypotheticals or writing of public presentations. You can't disclose identities of any clients. And that you shall maintain privacy in the storage or disposal of any records. So you're going to have to, use Shred-it if you've got actual paper files. If you have electronic files, you have to be very careful as well, that you are not in any way exposing them, and that you have standards that you set up for privacy and storage. Okay. Rule 15.275. Notice and the initial session. So at an initial meeting, you need to give written notice of fees, the method of payment that you accept, and how you collect. At the initial meeting, you have to describe the terms of the order of referral. Okay, and this is all to cover you so that the client is completely informed and you have a record of them being informed. Because if you only talk about it, which, you know, of course you do talk about it with the client, but if you only talk about it and you don't have it in writing, then there's no way to prove that it actually occurred. So inform the participants in writing of the following: of your prohibition against dual roles, that you have parenting coordination is an alternative dispute. You're kind of giving a little definition of it, where a parenting coordinator assists parents in creating or implementing a parenting plan. You want to let them know that the parenting coordinator may provide education and make recommendations to the parties. And with the prior approval of the parents and the court, you can make non-substantive decisions in the case. You want to inform them that the communications, as we've been talking about in many different sections, the statute and the rules, that the session is confidential, except where disclosure is required or permitted by law, and that all the fees and costs, the method of payment, and collections related to the parenting coordination process is clear in writing, and that the court's role in overseeing the parenting coordination process, including a party's right to seek court intervention if they don't like what's going on, if they have issues that they want addressed, that they can seek court intervention, and that they have a right, of course, to seek legal advice or to speak with their attorney about anything that you're doing in the parenting coordination process. And you want to also inform them the extent to which they are required to participate. So those are the things that would be very good to have in just a standardized welcome letter, basically, along with a full explanation of how they can make payments and your retainer and how it's billed. Rule 15.280 is fees and costs. Advance notice of a change in fees and costs in case that occurs, you know, yearly for you. And then maintaining financial records to support charges and services. You want to make sure that you have retention of those and maintaining those records. On request, you need to be able to make an accounting to the parents and the attorneys or the court about the fees. Same service to both parties, regardless of who is paying, whether one is the primary payer or the only payer, or they're both splitting it 50-50, you give the same service to both of them. Be honest, of course, in your time entries. Prorate your expenses. If you have, for instance, a few cases on the same day where you're traveling to a location, allocating those expenses accurately so it doesn't look as if you are double billing on something. Provide a written explanation of fees to the parties, as we just said, and their counsel prior to the parenting coordination process beginning. The explanation of fees has to show a basis for the amount of the charge for services to be rendered, including minimum fees for travel time, amount of charged time for postponement or cancellation of a session, and whether there are circumstances under which such charges will be assessed or waived, and a basis and amount of charges for any other items that you might be doing. And you know, it could be anything from, we talked about the travel and about sessions. So maybe you have differences in charges or fees if you're doing, you know, emergency calls or expedited type calls. Parties pro rata share of the parenting coordinator's fees and costs if previously determined by the court or agreed to by the parties. You want to have that in writing. There are no contingency fees or fees obviously based on an outcome of the process. So there's no such thing as you pay for all of the positive things you get and you don't pay for any of the negative things that you don't like. But Also, just no contingency fees and no referral fees or commissions. Rule 15.290 is entitled Safety, Capacity, and Protection, and that is really talking about monitoring for issues that can be safety issues and issues of concern to the parties in your case. So you're monitoring for domestic violence, for substance abuse, for mental health issues. If it's unsafe to continue the process for whatever reason, whether that's unsafe for you, unsafe for the other party, unsafe for the children, terminating the process of either party, if either party is incapable of participating meaningfully. That is something that you should be watching for, because that has happened as far as my practice is concerned. And at that point, it really is important to really terminate the process. Okay, so now we're going to move to the last section. Let me check my time here. And we are over time, so but that's okay. Discipline is 15.300.300. And just quickly, the purpose, the rules apply to all proceedings before the rules violation complaint committees and hearing panels of the Parenting Coordinator Review Board. That's the PCRB. Rule 15.330 establishes 20 people on the PCRB. It's 6 judges, 10 parenting coordinators, 5 of which are non-attorneys and 4 are attorneys. And they are appointed by the Supreme Court for 4 years and cannot serve more than 3 terms. That's the PCRB, which is that Parenting Coordinator Review Board. There are also Rule Violation Complaint Committee. In Rule 15.300D, each RVCC is composed of 3 members of that main PCRB that we just went over. The RVCC is assigned to a single case to investigate. Each RVCC is composed of 1 judge and 2 PCs from different backgrounds, mental health or, a lawyer. Majority vote controls their decisions when they receive a complaint, and Rule 15.335 sets forth the powers of the RVCC. Rule 15.345 is a rule violation complaint process. And again, you can go over and read that. It just basically is a complaint driven by anyone or by the DRC, is brought before that RVCC committee. And the DRC sends the complainant notification that a complaint was received within 10 days. And the RVCC's job is to determine if it's facially sufficient to go forward. If it isn't, it gets dismissed. If it is, then the parenting coordinator is given a copy and served with it, and they have to file a response within 20 days. What results can occur is that the RVCC could find no probable cause or could find probable cause and can either draft formal charges and forward that to the DRC, and then it's assigned to a panel for basically a hearing, or file non-referral containing a short and plain statement of the rules and reason for not referring. Can draft formal charges and retain a member of the Florida bar to conduct an investigation and draft a formal charge. Could be also dismissed by the complainant themselves. 15.350 is the hearing panel procedures, and that covers the prosecution of formal charges. The burden of proof is clear and convincing evidence per the rule, and sanctions are provided in Rule 15.360, and that's some oral admonishment, written reprimand, additional training, restriction on the types of cases that the person can take, and possibly suspension. Rule 15.380, this is a confidential disciplinary proceeding, all the way up to until a finding of probable cause or no probable cause. Okay, it is confidential through all the stages, but then once there's a finding of probable cause or no probable cause, it's not. Parenting coordination is dealing with HCPs, like we talked about earlier. Obviously, HCPs are very comfortable in the litigation process and complaint process. They are the highest conflict parties in the family law system. That's why they have entered into parenting coordination. With the types of high conflict people that we serve, it is wise to document and keep good records. Read and be very familiar with these rules and your responsibilities and your rights. Parenting coordination can be very fulfilling, but it is also very difficult because of the HCP clients, and you cannot allow yourself to be detrimentally affected professionally simply because of the average client being so high conflict. Know the rules and do what you need in order to ensure you are practicing professionally and that you can protect your reputation and your business. Thank you so much. I enjoyed talking with you. Sorry I went a little over time, and take care.